Friends, good afternoon and welcome. So this is In the Movement. This is a webinar series from Equal Justice USA and the Evangelical Network. And our goal here is to give a space to really be able to engage and elevate work of people doing work around justice in the movement, in the justice movement. So my name is Sam Heath, and I'm with EJUSA, and we're a national nonprofit. We do work around death penalty repeal, restorative justice, and community safety. And my branch of EJUSA is the Evangelical Network. And so my role is to engage Christians across the country about all of these things, to talk with them of how do Christians think theologically about this? How can Christians engage in matters of justice in practical ways? And one of the cornerstone, well, the cornerstone belief really in this webinar is we talk about mass incarceration, but we talk about that not as the core problem that we want to be solved, but it's a symptom. It's an expression of something else. We within this country rely on punishment as a solution to harm when it happens. And that knee-jerk reaction seems to largely be based on fear. And a fear-based response isn't sustainable. It often isn't safe. And everything that we see with the criminal legal system really seems to stem from that. And that's especially poignant for Christians. As I was telling my kids a few days ago, the most repeated command in Scripture is do not fear. So it doesn't mean that we're not going to not encounter frightful things within the world, but that Christians can navigate the world in this way with a settledness, with a peace, with an identity. And we can bring that hope and that steadiness into other places and spaces. So that's part of the conversation that's taking place right here. The topic and the big piece that we're going to look at and dive into today is looking at the death penalty, especially within Oklahoma. And for the first time on this series, looking at in-depth of a specific individual, his story and his case, Tremane Wood, who's on death row in Oklahoma. And we'll talk through who he is and what's happened and where things are with his situation. There's a lot to share. I'm hoping that you all will have a lot of questions. And so we have his attorney here, Amanda Bass, who is working tirelessly in lots of areas and facets on his case. And so, Amanda, if you want to give just a brief hello of who you are, and we'll really move into things in just a bit more.
Sure. Thanks, Sam. Thank you so much for having me. It's a pleasure to be with you today. I am an attorney and I represent people who have been sentenced to death in various state jurisdictions. I have clients in Arizona, where I live and work primarily, and also clients in Oklahoma, like Tremane, who we'll talk more about today. A big part of the work that I do day to day involves examining a person's conviction and their death sentence and identifying where there might be violations under the United States Constitution, because then we'll raise those constitutional issues in federal court. And a big part of what I also do involves representing people sentenced to death in state clemency proceedings, which I can talk more about, but are essentially proceedings that happen very close in time to when an execution is scheduled to occur, and it involves petitioning the leaders of a state for mercy.
Amanda, I'm so glad you're here. There's so much to go through and so much I want to ask. So as people have questions that they want to ask you throughout the time, we'll talk about for about 45 minutes, and then we'll save some time at the end. So anybody who's listening, you can feel free to put questions in the chat or in the Q&A feature, and we'll make sure to come back to those at the end. And any link or anything that Amanda or I mention, any website, or if we put something in the chat, we're going to make sure to capture all of that. You'll get an email probably tomorrow with an audio and a video recording of this webinar and all of those links there. So you can just listen and engage and don't feel like you need to furiously grab all of those things. Also, I see people doing it, which is so great. Feel free to put in the chat your name, if you're with a group, where you are within or outside of the country, because we'd love to see that we have a lot of individuals from lots of walks of life from all over, at least the country, here right now. So a couple of things to orient us with all of this. This statistic is one that we share every time because in some ways it's the most damning statistic that exemplifies mass incarceration. And then we'll zero in on Oklahoma. But you might have heard before that The United States has about 4% of the world's population, and yet about 20% of the prisoners or the individuals who are incarcerated globally. So immediately we see that within this nation, we have an obsession with incarceration at a rate that's unprecedented from other countries and civilizations throughout the world. The peak was at about 2.3 million. And right now we've got just under 2 million individuals locked up within the United States. But we also can't forget there's an additional 3.7 million people who are on probation or parole. We have thousands, about 5,000 jails and prisons across the country, in addition to about 1,300 juvenile detention centers. If we're talking about the death penalty, let's make sure we keep in mind where things are. There's the federal death penalty, there's the military death penalty, and there's death penalty within states. 23 states have repealed the death penalty, most recently here in Virginia, or here, which is where I live, here in Virginia. So 27 states still are able to execute. The federal government, as we said, still can. Under President Trump, there were 13 executions, which was more than anybody had done as an administration in at least the last 40 years. So in last year in 2023, 24 individuals were executed. So these are some of the facts about the death penalty. And some of my deep, engaging, rich conversations with people about the death penalty, we go into, why does somebody want the death penalty? And often 6 arguments or thoughts come up. And then the 7th one is where things get really deep. It's usually pretty quick and easy to show that the death penalty is applied in a racist manner. We know that the death penalty is wildly expensive, both the trial as well as actually doing that execution. We know that the death penalty does not deter crime. We know that it's applied in an arbitrary manner. We know that it's done in a torturous manner. And we know that it is not a path of healing to murder victim family members and their recovery from what's happened to them as well. Those are pretty easy to look at, the data and the stories around. The best conversations that I get to are when we talk about that people often want someone just to be punished. And that's a great conversation because then it becomes a moral, a philosophical, and at times a religious conversation. And Oklahoma is a very religious state, kind of off the charts in some ways that very few states in the United States are, up there with Alabama, with the vast majority of the population being religious, the vast majority being Christians, and the largest group within that being evangelical Christians. So a couple of things to orient us with Oklahoma and its death row and where things are. There's about 35 individuals on death row. I believe there's one woman that's there on death row. And over the years, there have been 10 exonerations. So 2 years ago, things were particularly bleak within Oklahoma because they had scheduled out an execution every month for about the next 2 years. Then corrections officials wrote to the attorney general, requested that that be spread out to a longer period of time because of the difficulty and the trauma that was going on there. And that was spread out. A request has been made to spread that out even more. Initially, it was 60 days. The request now, I believe, is 90 days. So there's a recognition of the toll that it takes to be able to sustain that as a state. Recently, there was some legislation in Oklahoma that was looking to have a moratorium on the death penalty for 2 years. It passed unanimously out of committee and then did not advance much further than that and died, I believe it was, on the House floor. A lot was learned. The hope is that that will come back next year and progress even more. I want to share one poll and then we'll kind of hold off on things like the Death Penalty Review Commission report, Amanda. I'd love for you to talk about that more. But one
Sure.
poll here, I'll put this in the chat so people can see it because it's, to me, it was jaw-dropping and helpful. There was a poll that was done last year, and it showed that 77% of Oklahoma voters support pausing executions. And the majority favor replacing death penalty with a life sentence or with life without parole. And this also, this poll went on to find, did not affect somebody, an individual who was within the state legislature. Their position on this did not seem to affect that person's vote, meaning this is something that we can pursue without quote unquote political consequence for those that are in the state legislature. So Oklahoma seems ready to do something else. And we're going to get into why Oklahoma seems so uniquely ready for that. So that's a lot of things, but we wanted to really set the stage for what's happening in Oklahoma and how it is this really, really unique space. So Amanda, here's what I want to do and kind of ease into this. I'd love to give some more background on you and how you came into this work. And then let's talk about Tremane and his case and kind of walk through piece by piece what happened in December of 2001 up through today. So you said a little bit before, but you named a lot of positions and a lot of things, but kind of practically and on the ground, as an attorney, what does the bulk of your job look like?
It's a great question. Well, first and foremost, I work with a team. It's a large team of folks that includes another attorney or two. We have two incredible investigators who work with us. We also have a paralegal and other support staff. And really, our job primarily is to develop a deep understanding of our clients' cases when they first arrive in our office. So our job involves a lot of reading initially, because by the time a case gets to my office in the federal defender system, a person has already been convicted, they've already been sentenced to death, and they have already been through several rounds of state appellate review unsuccessfully. And so we have to develop a deep understanding of what happened in our client's case and in his or her life up to the time it arrives at our door. And at that point, we can then begin to assess, well, what questions do we have about what happened at the trial? What evidence didn't get presented that we would have expected to see? What kind of defense did this client have? Were there witnesses who were or weren't contacted who had relevant information that would have been important for a jury to hear at the trial stage or deciding whether to sentence the client to death? So it involves a lot of record review, a lot of independent investigation. It also involves close contact with our clients. We see our clients frequently. We have regular phone calls with our clients because we have to also hear what our clients have to say about what they went through, about what happened to them, which also informs our advocacy. So once we have a comprehensive understanding of what happened previously and what do we need to investigate going forward to sort of fill in the gaps, that then frames our advocacy, whether in the form of the kinds of constitutional claims we raise to the federal courts, or whether we deem it appropriate to try to go back to the state courts to get them to look at an issue anew, or whether it involves petitioning the executive branch in a given state for mercy.
It's so much that this team I know goes through of material. I mean, I just in the past couple of weeks, I've gone through some of the briefs and some of the things that you've submitted that you've sent me and been able to look at. And that's just dozens and dozens of pages. But that's after all of the other hundreds and hundreds of pages that you all have gone through. There's so much to review with this because in a sense, you're presenting someone the entirety of their life that the system is really locating around one moment in time.
Exactly. Yes. And this is why it really is impossible to do this work in isolation. We really rely on everyone on the team because it is a profound amount of paper to go through. And then while we're also sort of going through all of that, we're requesting new records, we are identifying new witnesses, we are engaging with experts who can help us understand something about our client's life or history. So the team is really what makes it all possible.
It's so much beyond just one person, both in good ways and in just practical, it sounds like. How did you get into this specific line of work? I mean, I guess in general, I'd love to hear, how did you move into law, and then how did it narrow into this specific focus?
Sure. Well, I grew up in a Christian family and consider myself to be a follower of Christ. And really it was, I think, a combination of Christ's message of radical love and justice and mercy that was a North Star for me as I was, growing up and figuring out what I wanted to do beyond college. I think I also drew a lot of inspiration from the lessons that I learned about the various liberation struggles of marginalized people over time for rights, for inclusion, for recognition. And so I think the combination of those things really sort of informed my sense of wanting to do something meaningful, wanting to do something, justice oriented, but specifically on behalf of marginalized individuals. I had the experience of taking some time off during college to do voter registration work in Georgia. I
Mm.
was in Macon, Georgia, and I lived there for about 8 to 10 months in 2008. And I was doing voter registration work, and I realized that one of the barriers to voting access also had to do with access to resources. So there were people in rural counties throughout middle Georgia who were eligible to vote, but who didn't have a means to get to the Board of Elections to register because the bus route didn't stop there, or they didn't have access to a state sanctioned voter ID card. There were just various barriers that I saw to participation. And the law was really instrumental in erecting
Mm.
those barriers. And so
Mhm.
that piqued my interest in understanding more about the law and how the law can both be a tool for bringing about positive social change, but that can also be a tool for maintaining inequity and exclusion. And so that sort of drove me to go to law school to want to understand more about the law. And I didn't really have a clear sense at that time of what kind of law I wanted to pursue, what kind of justice path I wanted,
Mhm.
to walk down. And so it was really a moment of discovery for me. I took courses on international law and human rights. I also took courses on the death penalty and the Eighth Amendment. But it was really formative for me when, during my second year in law school, I had the great fortune of being accepted as a legal intern at the Southern Center for Human Rights in Atlanta, where I worked with some incredible attorneys on the uh, litigation dockets, the capital and non-capital litigation dockets, who really exposed me to capital post-conviction work.
Mhm.
And so that sort of brought together, my interest in human rights, because the death penalty, in my view, is violation of human right number one, which is the right to live and to exist and to be a full participant in this world.
Mhm.
But also brought together constitutional law and was sort of pushing for the rights of clients through a constitutional law framework in US courts, not in some international legal body located overseas, but right here in places like
Mhm.
Alabama or Georgia.
Mhm.
So that exposed me to capital post-conviction work, and that's what I've pursued ever since.
Wow. I'm hearing echoes of a couple things. I mean, EJUSA began by recognizing that there was a human rights crisis here within the US. There was some work that was going on in places elsewhere in the world, and the thought was, well, with the death penalty and with the brutality of policing, we should engage that here also within our own borders. And to your
Mhm.
point, there's this recognition of that as a human rights issue.
Right,
Increasingly, I know there's a current conversation at the UN right now around the death penalty.
right.
I'm also reading the new biography on King, and thrown back to you talking about voter registration and legal
Mhm.
barriers to being able to vote. And in my mind, I'm in the 1960s, but this is present day that so many of these
Yes.
things still exist and need to be retooled and done and undone.
Right. And that was really a formative experience for me, doing that voter registration work in Georgia in 2008, because I had the same sort of dissonance where, the things that I was encountering in terms of the legal structural barriers to access to participation in our democracy were things that I thought were relics of the past.
Mm,
But no, this was 2008 Georgia, where these kinds of barriers were still very much alive and well.
mhm. Oklahoma made international news about 2.5 years ago as things led up to the potential execution of Julius Jones. So
Mhm.
you were involved with that work as well. There was a legal battle. There was, again, global activism around that, led by his family and the work of C.C. Jones Davis and many others who came together to call attention to Julius Jones. Can you say just a bit about Julius, both that poignant moment leading up to about 2.5 years ago, and where things are with him now? Because he's still there. He is still imprisoned in Oklahoma.
Mhm. Yeah, I and my office and the team that works and represents Tremane and is fighting for him also represented Julius, and we represented him between 2016 and 2022, and our office was appointed specifically for the purpose of petitioning the Oklahoma Clemency Board and Governor for clemency. And so Julius's case, like Tremane's, really does illustrate a lot of the systemic flaws with Oklahoma's death penalty system. Issues like the lack of resources for inadequate defense. Both Julius and Tremane had ineffective defense lawyers at the trial stage who didn't put on a defense for them, who didn't give the jury what it would have needed to know to make a different decision other than death. There were issues related to racial bias in the number of Black people who were, for example, struck from jury service in both Julius's and Tremane's cases. There were issues related to the kind of race of the defendant, race of the victim effect, which the Oklahoma Death Penalty Review Commission report that you talked about initially, Sam, identifies as creating a greater statistical likelihood that someone like Julius, like Tremane, who are accused of killing a white victim, are 2 to 3 times more likely to be sentenced to death on that basis, controlling for other circumstances of the crime. So Julius came to the brink of execution. He was 4 hours away from being executed before Governor Stitt showed mercy and spared his life. He is serving a life without parole sentence now and is represented by new lawyers. He is being represented by the New York Innocence Project and a law firm named Covington, who are, carrying his case forward and trying to identify ways to potentially get back into court to take on his unjust conviction.
It was a wild moment because it was 4 hours before his execution that the notice from Governor Stitt came down. And I know that there are several people on this call who were really intimately involved in, if you look at the case study that was produced on it, about 1 billion touch points across the world that it took in order to bring attention to this and the concerns that people had. I'll put in the chat, and of course, I'll put in the email as well. The Justice for Julius campaign did a case study on this and chronicled Julius's story and the story of the campaign around him. And the campaign was exceptional in the scope that it had, but so many pieces of Julius's case, unfortunately, aren't exceptional because there's so many pieces and threads through other cases, including with Tremane's. So, Amanda, there's a lot of ways to answer this question, and we'll tease out more than one way, but maybe let's just start with, who is Tremane Wood?
Well, I have to say, Tremane is first and foremost a remarkable, remarkable human being who is profoundly resilient and who daily inspires me and everyone on the team fighting for him, just in terms of his positive outlook on life, his desire to not be limited by his circumstances on death row, to better himself, to be a mentor to people on death row, to young people in his family. So I just want to say that first and foremost, he has been on death row for 20 years in Oklahoma, and he got there after being convicted of what's called felony murder for participating in a robbery with his older brother when he was just 22 years old, during which his older brother unexpectedly and tragically killed someone. Now, under Oklahoma's felony murder rule, the state could and did seek the death penalty against Tremane without ever having to prove that he killed anyone or that he intended to kill anyone. And Tremane is actually the only person on Oklahoma's death row who is there for a pure felony murder conviction. The added tragedy of Tremane's case is that even though his brother confessed to being the one who killed the victim during this robbery gone bad, his brother was sentenced to life in prison with the benefit of better lawyers who actually defended him, whereas Tremane was sentenced to death as a result of a lawyer who admittedly did little to no work on his case at all.
Mm-hmm.
So I can talk more about that, but that's Tremane and his case in a nutshell.
Yeah, it's so much. I mean, we'll send everybody the website that talks about Tremane, but one piece that it highlights, and this comes up so much as it should, in talking about Tremane, is he's on death row when he has not killed anyone. He is on death row when the person who confessed to the killing was sentenced to life without parole. So can you talk a little more about, it was December 31st, 2001, I believe. What happened that night? And then I want to eventually move into the felony murder piece. I'm channeling my inner Shane Claiborne, who's an activist who would be really animated at this point, I think, and saying, now help me understand this again in his Tennessee accent about kind of the absurdity of felony murder. I'm going to hold back on that, but what are some of the other details about what happened that evening so people understand what we're talking about, and then let's figure out the felony murder piece.
Sure. Well, Tremane was living with his girlfriend at the time. They had a young child. He was working a job. He was doing well. His older brother, who had a history of involvement with the law, had recently gotten out of prison after being convicted of a felony. And on December 31st, 2001, Tremane's older brother had the idea to let's go and rob someone, and Tremane, you've got to come along. And so Tremane and his brother, and also two other female co-defendants, robbed two young men, Ronnie Whipf and Arnold Kleinsasser, at a Ramada Inn outside of Oklahoma City. And during that robbery, Tremane's brother ended up stabbing one of the robbery victims and killing him. Now, the state pursued the death penalty against both Tremane and his brother, and because they were co-defendants, their trials were severed. So they had separate trials, and the court appointed them separate lawyers. Tremane's brother was appointed the Oklahoma Indigent Defense System, which is a state agency that employs capital defense lawyers, investigators, and people who are experienced in defending death penalty cases and have the resources to do that. By happenstance, Tremane was represented by an appointed solo practitioner who put up no defense for him, who admitted later that he didn't do much at all to represent Tremane or to investigate his case. We have located an invoice for this lawyer showing that over the nearly 2 years that he was assigned to represent Tremane before trial, he worked only 80 hours on Tremane's case, and 60 of those hours were just showing up for the trial. And so there was significant information that the jury did not have in Tremane's case. And when you compare that to the zealous representation that Tremane's brother had, who admitted to carrying out the killing, but had 3 experienced capital defense lawyers, 2 investigators who, scoured the earth for information relevant to his defense, you can see the difference in sentencing outcomes and how the sentences here are directly traceable to the resources that went into defending Tremane as opposed to his brother.
You said it was by happenstance, but how does that happen that one individual gets assigned a single lawyer, the other gets assigned a state branch with a team? What accounts for that disparity?
It was the judge's decision. So it was the Oklahoma District Court judge who, in deciding to sever Tremane's and his brother's cases, decided to give Tremane's brother's case to the Oklahoma Indigent Defense System. And because the Indigent Defense System couldn't also represent both of them, because otherwise there could be a conflict, he decided to pick a lawyer, the court did, from a list of lawyers who can take on capital cases in Oklahoma, and gave Tremane one of those individuals instead. And that lawyer didn't use an investigator. As I said, he was a solo practitioner, and he, to his great credit, later admitted and provided us with sworn statements where he acknowledges that he was going through a difficult time in his life. He didn't do enough or at all to defend Tremane, and so had a lot of regret about that fact.
Let's go more into the felony murder piece. So when that is brought up within a court proceeding, you said it is not necessary for the case to be made that that person actually committed the murder. So say more on that. I mean, again, one of the many astonishing pieces about Tremane's case is he is on death row for having murdered someone, but yet didn't, because of this law that allows for kind of this exception.
Right. It's something that is often difficult for people to wrap their heads around, because it seems innately unjust and disproportionate that someone could get the death penalty despite the state never having to prove that they killed anyone or that they intended to kill anyone. And really, it reflects a kind of policy judgment that state legislatures make about wanting to penalize people through this extreme sanction who participate in a crime. And so they're on the hook. It's as if you participate in a crime, it doesn't matter if you didn't kill anyone. It doesn't matter if you didn't intend to kill anyone. You can still get the death penalty for just being there. And that's what happened in Tremane's case. That is a law that was on the books in Oklahoma. It's a law that is still on the books in Oklahoma and other jurisdictions like Arizona. And as a result, you can have people like Tremane who are facing execution, even though the actual killer has gotten a lesser sentence.
Wow. Wow. Now, it was a white man that was murdered. Is that right?
Yes.
So to zoom out, I want to remind people or tell people that if you look at all the factors that are predictors of whether or not someone receives the death penalty, the number one factor that's correlated with that, interestingly, but maybe not shockingly, is the race of the victim. And or put another way, if the victim is white, it often ups the chances of someone receiving a death sentence, particularly if that's a person of color, even more so if specifically that person is Black. Well, that's a general statistic and observation in lots of cases, but where does race or racism come out within this case?
Well, that is one clear piece of it. And in 2018, based on that study that came out specific to Oklahoma, we filed a petition in the Oklahoma Court of Criminal Appeals and in the U.S. Supreme Court challenging Tremane's death sentence on the basis of the statistical evidence that in Oklahoma, he was more likely to receive a death sentence based on his race and the race of the victim. We argued that that was a violation of the Eighth Amendment, which prohibits the arbitrary imposition of capital punishment. But unfortunately, there's a case, a Supreme Court case called McCleskey versus Kemp from 1987 that essentially says, discrimination in the administration of the criminal justice system is inevitable.
Yeah.
And statistics showing that Black defendants are more likely to receive a death sentence for killing white victims or for being accused of killing white victims is not enough to show that the Eighth Amendment to the U.S. Constitution is violated. So the court really closed the courthouse doors to any kind of systemic challenge to the United States death penalty on the basis of racial disparity. But after this report came out, we asked the court to revisit McCleskey to overrule McCleskey based on the compelling evidence that race does impact death sentences in the United States and in Oklahoma, and in Tremane's case in particular. And interestingly, the Supreme Court kept reconferencing that cert petition in Tremane's case for over a year. I think it was like 26 times over a year that the court just kept rescheduling and rescheduling its conference over that petition before ultimately denying it without explaining why. So that was unusual, but for some of us who were reading the tea leaves, we wondered whether or not there might have been some appetite among members of the court at that time to really revisit this notion that racial discrimination in the administration of America's death penalty is inevitable. So that's one of the ways that race shows up in Tremane's case. It also shows up in the form of invidious discrimination in the way that the jury was selected. So every Black person except one was struck from service on Tremane's jury. So he was convicted by a majority white jury with one Black member who has since that time come forward and attested to the ways in which she felt bullied into voting for death. She felt pressured to vote for death. And she went along with a death sentence for Tremane under those sort of very difficult, coercive circumstances.
You referenced this earlier, and I know this is a big question, but you just talked about the jury. What is it that the jury did not hear within this trial?
Well, there's so much that the jury didn't hear. In looking at how long Tremane's entire trial was, from the first stage where the jury was deciding on his guilt to the sentencing stage where they were deciding on whether to sentence him to death, 6 days is how long his trial was. And just to put that into perspective, I have cases here in Arizona where a death penalty trial and sentencing proceeding lasted for 35 days. And that's pretty typical when a case is defended the way that it should be defended. So his trial was very brief, which makes sense when you look at how little his lawyer did to defend him. And his penalty phase proceeding began and ended over the span of like 4 hours. Okay, so 4 hours was what the jury had to go on in deciding whether to sentence him to death. And so the jury didn't have significant information, for example, about the fact that Tremane's brother really pressured him to go along with this robbery. We have found witnesses who were with Tremane and his brother that night who have said in sworn statements that they saw the kind of pressure his brother was putting on him to just come along, have my back, you've got to come along with it, go along with this. That is relevant in assessing Tremane's culpability for participating in something like this. Those witnesses were never contacted by Tremane's lawyer, and the jury never got to hear what they had to say. The jury also didn't know that Tremane was profoundly remorseful for the role that he did play in the robbery. Even though he didn't kill anyone, he was still deeply distraught by what happened, and the jury never heard that. In fact, the state was able to argue that Tremane lacked remorse and argued that his lack of remorse was a reason why the jury should sentence him to death. And his lawyer did nothing to push back on that, to show he was profoundly remorseful. And here are witnesses who could have testified about that if his lawyer bothered to work more than 80 hours on his case over a 2-year period. There was also significant information about Tremane's life history that his lawyer just touched the surface on through a handful of witnesses at the penalty phase, that would have been important for the jury to understand about Tremane's life and his upbringing and the complex trauma that he endured, and that also informed the kind of bond and relationship that he had with his older brother. That is important context for understanding how he got involved in this in the first place. And so we also know from the only Black juror who has since come forward to support mercy for Tremane, and also from other jurors who have provided sworn statements that this is the kind of information they didn't have, that they would have wanted to know in deciding whether to sentence Tremane to death. We also know from 2 jurors that they were confused about their role and about the options that were available to them when they sentenced Tremane. So we know that they were confused about whether they had to be unanimous. They didn't have to be unanimous. One juror could have said, I support life, and Tremane would have gotten a life sentence. They thought, because they were confused by the court's instructions, and that they had to be unanimous either on death or on life, and that was it. And so again, Tremane's lawyer did nothing to dispel that confusion among the jury about the options available to it in deciding Tremane's appropriate punishment. And that's just the tip of the iceberg.
Yeah, there's so many points where this could go and did go awry. And I want to make sure one thing is clear for people listening, that in a capital trial, there's 2 phases. There's the phase determining the guilt or innocence of the individual, which is separate from the actual sentencing of someone. And at both of these points, there was confusion, there was misinformation, and lack of information.
Right. And it's hard because when there's a fatal lack of information at that stage and someone is convicted and sentenced to death, it becomes so difficult at later stages of appellate review for a person to ever get relief. And so having a robust defense at that initial stage is the most critical, because one of the things that we've seen in Tremane's case is that, you know, his appellate lawyer's attempts and his post-conviction lawyer's attempts and our attempts to go back to the courts and say, there's been a miscarriage of justice here. Here's new evidence showing why Tremane's death sentence is unjust. Here is new and compelling evidence that his jury didn't have that would have been important for it to consider. You know, the courts are all procedurally barring the claims because it's hard to get back into court to try to undo an unjust conviction and sentence after the fact. And so a lot of people might think, well, you know, they've been through multiple rounds of appellate review. It must mean that the courts found this death sentence just. No.
Yeah.
All it means is that the courts often aren't even looking to that question and are instead saying, are you procedurally barred? Is this timely? Is this constitutional error harmless? And that is just a very difficult scenario within which to be working, which is why clemency becomes so important as a fail-safe before an execution is carried out.
Yeah, it's incredibly layered in thinking through all that and all the facets of the pieces of this. So I want to remind people listening that if there's questions that come up, if there's thoughts, I see a couple of those already. Put those in the chat, put those in the Q&A feature. We'll get to those in a bit. But I want to turn a little bit to Tremane's incarceration time and how that's been, where things are now. You graciously gave me the green light to write to Tremane, and he wrote to me and just was describing some incredible high points of things and some moments of beauty and hope that are there, and also some weighty pieces. So what does life look like for Tremane right now?
You know, life is difficult. You know, Tremane, as I said, he is resilient and he makes the best of a very, very difficult situation. You know, Tremane is on a unit at the Oklahoma State Penitentiary called A Unit, which is a different unit than where death row used to be just a few years ago. Death row used to be located on a unit called H Unit, which is essentially an underground bunker, which is where death row was located, where Tremane lived under, you know, near 24-hour solitary confinement for 16 years.
He said that they called it the tombs.
Yes.
Wow.
Because it does look like a tomb. When you walk in, when I would visit Tremane, you know, you walk into essentially an underground bunker and there are no windows to the cells. The execution chamber is located right in the same pod where the men were housed and where Tremane lived for 16 years. And so that kind of proximity to the execution chamber and that constant reminder of one's, you know, looming execution, seeing people who you've lived with for decades being walked to the execution chamber. I mean, it's a very traumatic set of circumstances. So Tremane is not there anymore, thanks to the great work of the Oklahoma Capital Habeas Unit and the Oklahoma ACLU. They were able to negotiate with the prison to get Tremane and a number of other men moved to where they're now located on A unit, which is better comparatively than where they were, but also still difficult in terms of the limited access to, outdoors, the limited access to recreation. But notwithstanding those difficult circumstances, Tremane has been a leader. He was one of the few people selected to participate in a group pilot program for recreation. And that program has gone really well and may be expanded to include other men, but he was one of the folks who the prison trusted and selected to be part of this pilot program. He, for quite a while, held jobs as an assistant orderly and as an orderly that saw him having greater freedoms within his pod, which again is an indication of the responsibility and trust that the prison officials had in him. And he's also an enrolled college student now. Tremane is taking American government at Rose State College, and we're so proud of him. He's gotten 98% on his first exam and is studying and working hard to do well on his other exams, but he's enjoying the process of learning. And so I think when I say Tremane is truly an inspiration to me and to all of us on his team, it's because despite the difficult, traumatic, inhumane circumstances that he's endured and the threat of an execution date coming down for him any day, he is still able to rise above and beyond that and to be really a model for so many.
Yeah, he mentioned to me that the exam score, which I think he was especially excited about, he talked about working to mentor other people who were there. He talked about the proposal that he wrote to the DOC for a trauma and grief group. I mean, he said there is really nothing that is offered in terms of rehabilitation, that it has to be self-generated. And again, you talking about his resilience.
Yes. It has to be generated because the prison essentially deems people who are sentenced to death as folks in whom it's not a good use of resources to invest in terms of programming. And that's unfortunate that that's the mindset. And I've been encouraged to see that some of that thinking is changing in large part due to the advocacy of people like Tremane and like folks, on the ground in Oklahoma at the ACLU and the Capital Habeas Unit and elsewhere to show the prison folks deserve and can have meaningful lives and make contributions where they are, even when they are sentenced to death. It's not okay to just write them off as if their lives cease to have meaning the minute they're condemned.
There's a couple questions I want to circle back to. One individual is asking, what does some measure of accountability look like for Tremane's former attorney through the trial? What was the result of that? Are there ways that the law would work to engage him within that? And I'm hesitating and having trouble with the word accountable as we think about in spaces like this about restorative justice. What does that look like? But legally, accountability is often defined in a really narrow way. So I guess just another way to put it is, what has been the result or the consequence as a result of that attorney's behavior?
Well, in Tremane's case, there has been no consequence. It's interesting because around the same time that this attorney represented Tremane, he also represented two other individuals who were also sentenced to death because of his ineffectiveness, and those individuals got relief from their death sentences because of his failures. In fact, one of them, James Fisher, is out of prison today. So I think in those cases, you can see that there was some form of accountability through the courts because they recognized these individuals got an ineffective lawyer, and so we cannot say that these death sentences are reliable because of that. But unfortunately, Tremane has not been a beneficiary of that same kind of judicial accountability.
Mhm.
And so, I mean, I think that that's one thing. There are ways that a person, depending on how egregious their representation is or isn't, they can get sanctioned through the State Bar Association or
Mhm.
disciplined, or they could also be taken off the list of lawyers who are appointed to take on capital cases. So all that to say, the accountability doesn't have to look like punishment for the lawyer,
Mhm.
or punishment, you know, um, you know, in the form of like getting disbarred or whatnot. Sometimes that is what happens.
Mhm.
But it can take a variety of forms.
Mhm. Another individual is asking about, and going back to the discussion about felony murder, are there any movements within Oklahoma to change that law and that possibility of something like Tremaine happening again, someone being convicted for and not having to have been found guilty of that actual crime or motivate or had the motive for it too?
Right. There's movement on that in Oklahoma. You mentioned earlier, Sam, the legislation that would have implemented a temporary moratorium on executions. There was also a bill that was that didn't make it out of the relevant committee in the House, but that had sponsorship and support that would have revised Oklahoma's felony murder rule such that a person who did not kill anyone or intend to kill anyone could not be eligible for the death penalty. They could set up
Mm,
to life without parole and spend the rest of their lives in prison, but they could not get the death penalty. And
mhm,
they also couldn't be punished more harshly than the person who did actually carry out the killing. And unfortunately, as I mentioned, that bill did not make it out of the committee, but I think it reflects that there is a growing understanding of and interest in taking this on, this sort of
mhm.
this injustice around punishment and it not being proportionate to one's culpability
Mm.
in Oklahoma.
So there's two at least two things I want to make sure people see, and we've mentioned one, and we'll send these out to everybody. One is that bipartisan review of Oklahoma's death penalty, and that report came out in 2017, and that's online, and individuals can see it. We'll send that out, but the recommendations that it have made have absolutely not been implemented. But it points out the things you're saying and so
Mhm.
many other pieces and parts and holes and failures. If we could even
Mhm.
have this process be successful within Oklahoma. So that's something to see. The other piece I want to point out is the Death Penalty Information Center put out a report. It was either last year or the year before last called Deeply Rooted. And we have one of the former executive directors of DPIC here on the call, which is exciting. What is the Deeply Rooted report and why might that be especially helpful for someone looking at Tremane?
Yes, thank you for bringing that up, Sam. And I saw that Tiana Herring is on the call, and she did an absolutely fantastic job authoring and researching that very power report, which draws links between the history of racial violence in Oklahoma and the modern death penalty. And so that report is a must read. It talks about everything from slavery to lynchings to the Tulsa race massacre and the way that the death penalty was weaponized as a tool specifically targeting Black people and poor people. And so it situates the death penalty and cases like Tremaine's within that broader history of racial violence in Oklahoma.
Mm. I want to put in the chat and we'll send this out in the recap email. The site that chronicles a lot of what you've mentioned here. And also on this site are these two reports. The Review Commission report is there, as well as DPIC's Deeply Rooted report. So people can dig into those. I want to share one thing that Tremaine said because it references a verse, and then ask you, Amanda, what can people do? What are some next steps if people are concerned or curious or upset, what they can do? But Tremaine was talking about his grandmother, and he said that his grandmother would often
Mhm.
quote a verse to him that he's found encouraging in this time. And he wrote it out for me, but it was 2 Corinthians 12:9. And it was, "My grace is sufficient for you, for my power is made perfect in weakness." Which the idea of grace and the importance of that in a situation like Tremane's is paramount. And thinking through another word in this verse, power, and all of these dynamics and the ways that it has been wielded are appalling and wild. And yet the Christian story is one of powerlessness, ultimately, of Christians coming and
Mhm.
loving and serving and being in positions of powerlessness for the sake of the other, and yet ultimately come under the great and good power that we talked about earlier. So it seems Tremaine is hearing that and hearing echoes of that from his grandmother, which from the tombs and now from the slightly less bad place that he is right now, that's in his head, which is beautiful. So what can people do in response to all of this?
Well, I think one is if you can go to Tremane's website and sign the petition calling for clemency for him, that would be absolutely wonderful and helpful. Because unfortunately, what we know is that we have to get people to care about Tremane's case and to make him an individual and to humanize him to Oklahoma decision makers so that he's not just a number in line to
Mm,
be executed. So please go there, sign the petition, educate
mm,
yourself about Tremane's case and about Oklahoma's death penalty system. You can do that through the resources, Sam, that you've shared, some of which are linked on the website, and talk about that with people who you
mhm,
might know and encourage them to take action. You can also find the addresses to where you can send letters of support for mercy for Tremaine, whether to the Oklahoma Pardon and Parole Board or to Governor Stitt. And then you can also always reach out, to you, Sam, or to
mhm,
me,
mhm,
if you have questions about what you can do or how you can support or elevate Tremaine's case within your networks or
mhm.
your social media spaces.
Yeah. And just a reminder to people, and to be clear, Tremaine doesn't yet have an execution date. The thought is that that may come soon. And if and
Yes.
when that does, there'll be a clemency packet, there'll be a clemency
Mm-hmm.
hearing. There will be action alerts that especially relate to that. And EJUSA and I'm sure others will be putting out information about that. So if you're on our email list, you'll also hear about that. There'll be more of a heightened point, an urgency to action, likely at some point soon. So I want to point people to next month, and then we'll start to wrap up here. So we're going to continue conversations around these topics. And so I just put in the chat there. I'll email you all this as well. Next month on May 23rd at 2 p.m., we're going to be talking with a ministry that's in Washington State called One Parish, One Prisoner. There's roughly the same number of individuals incarcerated in Washington State as there are churches. And one group thought, what if each church adopted an individual as he or she returned home from imprisonment and learned from that person, served that person, and built a community around them? And that group is called One Parish, One Prisoner. And so we're going to be hearing from that group and about their work and their expansion, hopefully beyond what they're doing within Washington State. It's a wild story of how they came into this and what that work looks like on the ground. It's a very, very on the ground way of how to love our neighbor. So, Amanda, the work that you do is detailed and gritty and all sorts of things. Thank you both for that work, for your dedication to Tremaine, and for coming here and sharing all of this. I appreciate you so much. Just the grace and communication with you. It is a light and a life-giving thing, but especially today, thank you for coming and sharing with everybody.
Thank you, Sam, and thank you so much for all of the work you and everyone at EJUSA do and for your support for Tremaine and so many others.
Yeah, thank you all for joining us, and hopefully we'll see you next month. Bye-bye.